As an avid student, I have always been drawn to books, but I must admit that not all literary works capture my interest, and I am selective about the topics I engage with. During my exam preparation, however, I have developed a growing curiosity about Indian polity, and the series we are studying has revealed many fascinating aspects of our Indian constitution. You may recall that I posed a question in the last video, and today we will commence our exploration of fundamental rights by addressing that very question. Before we proceed, allow me to introduce myself. I am Swati, your study partner, and I welcome you all to my channel Aspiration for Learning. Without further ado, let us begin. Yesterday, we concluded our lesson on a question, and if you were unable to find the answer, I would like to inform you that it can be found in the chapter of fundamental rights, especially in the section on the abolition of untouchability. So, this is the answer. A person convicted of the offense of untouchability is disqualified for election to the parliament or state legislature. You can notice here that this statement is true because the person is really disqualified for election to the parliament and state legislature. In this context, it is very crucial to recall that Article 17 prohibits untouchability and its practice in any form. Article 17 applies to both the state and private individuals. In 1976, the Untouchability Offences Act of 1955 was comprehensively amended and renamed the Protection of Civil Rights Act of 1955 to enhance its scope and make penal provisions more stringent. Notably, the term untouchability has not been defined in either the Constitution or the Act. The Mysore High Court held that the subject matter of Article 17 is not untouchability in its literary or grammatical sense, but the practice as it has historically developed in the country. I came across a question in a question bank regarding whether national awards like the Bharat Ratna were available. Upon researching this question, I found that the conferral of the Bharat Ratna and other national awards, including the Padma Awards, has been temporarily suspended twice, once between 1997 and 1980, and again between 1992 and 1995. The Supreme Court upheld the constitutional validity of national awards like the Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri, ruling that these awards do not constitute titles within the meaning of Article 18, which prohibits only hereditary titles of nobility and thus are not violative of Article 18. I think in this context we should clarify our concept and understand what provisions Article 18 makes regarding titles. You will find in this chapter that Article 18 evolves titles and mixes four provisions in that regard. Number 1 states that the state is prohibited from conferring any title except a military or academic distinction on anybody, whether a citizen or a foreigner. Number 2 prohibits citizens of India from accepting any title from any foreign state. Number 3 states that a foreigner holding any office of profit or trust in the state cannot accept any title from any foreign state without the consent of the president. And number 4 states that a person holding any office of profit or trust in the state is not allowed to accept any present or office from or under any foreign state without the consent of the president. As we have already discussed Article 18, let's attempt to gain insight into Article 19, including which right was repealed, when it was repealed, and whether the rights under Article 19 are applicable against private individuals. Originally, Article 19 comprises 7 rights, but the right to acquire, hold, and dispose of property was deleted by the 44th Constitutional Amendment Act of 1978. The remaining 6 rights are protected against state action only and not against private individuals. These 6 rights include: number 1, the right to freedom of speech and expression; number 2, the right to assemble peaceably and without arms; number 3, the right to form associations or unions or cooperative societies; number 4, the right to move freely throughout the territory of India; number 5, the right to reside and settle in any part of the territory of India; and number 6, the right to practice any profession or to carry on any occupation, trade and business. It is imperative to recall that the state can only impose reasonable restrictions on the enjoyment of these 6 rights as stipulated in Article 19 of the Indian Constitution, and not on any other grounds. The right to freedom, as enshrined in the Constitution, grants Indians the right to assemble peaceably and without arms, typically exercised on public land and not on private property. This right is guaranteed by Article 19 1b of the Indian Constitution but doesn't encompasses the right to strike. Furthermore, all citizens have the right to form associations, unions or cooperative societies, including the right to form political parties, companies, partnerships, societies, clubs, organizations, trade unions, or any body of persons. This right not only includes the ability to establish an association or union, but also to continue with it. However, the right to obtain recognition of the association is not a fundamental right. I previously stated that the right to strike is not encompassed within the right to assemble peaceably and without arms, which raises a question: can the right to strike be regulated by an appropriate industrial law? The answer is yes. The right to strike can indeed be controlled by an appropriate industrial law. You know that there are 2 reasonable restrictions under freedom of movement, which are in the interest of the general public and the protection of the interests of scheduled tribes. Freedom of movement has 2 dimensions, internal and external. Article 19 protects only the first dimension, while the second provision is dealt with by Article 21, which pertains to the right to life and personal liberty. If you were to inquire whether a state monopoly over a trade or business or service is permissible under the freedom of profession, how would you respond? Considering that all citizens are guaranteed the right to practice any profession or carry on any occupation, trade or business, but no objection can be raised when the state engages in a trade, business, industry or service either as a complete or partial monopoly to the exclusion of citizens, all or some, or in competition with any citizen without requiring the state to justify its monopoly. We will now attempt to comprehend 3 vital phrases: no ex post facto law, no double jeopardy, no self-incrimination. The principle of no ex post facto law stipulates that no individual shall be convicted of any offence except for violation of a law in force at the attempt of the commission of the act, nor subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. The concept of no double jeopardy asserts that no individual shall be prosecuted and punished for the same offence more than once. Furthermore, the principle of no self-incrimination dictates that no person accused of any offence shall be compelled to testify against themselves. Or you can say no person accused of any offence shall be compelled to be a witness against himself. It is essential to note here that the no ex post facto law is exclusively applicable to criminal laws and not to civil laws and tax laws. Are you aware that protection against double jeopardy is only available in proceedings before a court of law or a judicial tribunal, meaning it doesn't apply to proceedings before departmental or administrative authorities due to their non-judicial nature, and that the privilege against self-incrimination extends only to criminal proceedings, not to civil proceedings or other non-criminal proceedings. If you inquire about whether a person can be deprived of their life or personal liberty, I would respond that Article 21 stipulates that no individual shall be deprived of their life or personal liberty except in accordance with procedures established by law. This right applies to both citizens and non-citizens. In the Gopalan case of 1950, the Supreme Court adopted a narrow interpretation of Article 21, ruling that protection under this article is available only against arbitrary executive action but not legislative action. This implies that the state can deprive an individual of their right to life and personal liberty based on a law. The Supreme Court also held that personal liberty pertains solely to the individual person or body. However, in the Menaka case of 1978, the Supreme Court overruled its earlier judgment, adopting a broader interpretation of Article 21. It ruled that the right to life and personal liberty can be deprived by a law, provided the procedure prescribed by that law is reasonable, fair, and just. In effect, the protection under Article 21 should be available against both executive and legislative actions. We have not completed the chapter on fundamental rights yet, but the video is becoming excessively long. Therefore, I will stop here and attempt to complete the remaining topics in the next video. To conclude, I pose a question for you to investigate. The question is, how was the right to education incorporated into the list of fundamental rights? Please note the specifiers of how this right was added, whether it encompasses higher or professional education or not, and how this amendment impacted the DPSP and fundamental rights. I will repeat the question for you. How was the right to education added to the list of fundamental rights? Does it cover higher or professional education or not? How did the DPSPs and fundamental duties changes as a result? Invite you to find the answers to these questions. This concludes the video for now. I will see you in the next video. If you find this content helpful and informative, please subscribe to my channel. The comment section is available for your feedback and I appreciate your valuable opinions. Until then, stay focused on your studies and have a good day ahead. Thank you for being with me. Lots of love and regards from Swati, your study partner.